Hello and good evening, everyone. Welcome to this very important session. Today, in this session, we will be discussing a topic which usually sparks debate and headlines. The topic is related to appointment of judges in India. This particular topic, it always comes back after every few months. It is just back in the news and everybody starts debating about it, and the questions are asked: how judges are appointed, is the process fair and transparent, or is it that the judiciary has become more and more powerful? We'll take all these questions. In this session we will understand, we'll look at what the constitution provides, how the system of appointment of judges it works, and all this will be discussed especially in light of the recent two very important documents that are published by the Supreme Court just a day back. On 5th, two documents were shared. They are there on the website of the Supreme Court to for everybody to see. It in a very detailed fashion lays down step by step procedure regarding appointment of both High Court judges and the Supreme Court judges. So let's begin. Let's start with the fundamental law of our land, that is our constitution. With respect to Supreme Court, Article 124 of our constitution provides that judges will be appointed by the president, and in that process the president is supposed to consult with the Chief Justice of India and other judges if he deems necessary. Then for high courts, Article 217 provides similar thing. Again, the appointment is to be made by the president, and this time in consultation with the Chief Justice of India, the governor of the state, and the Chief Justice of the High Court. So, be it the Supreme Court or the High Court, in both the cases, consultation is a must. It is part of the process. So, how does this collegium system, it has come into being? What is it about? It was born out of judicial decisions, because you'll see, if you'll see the constitution, if you'll read the constitution, you will find that this word, the collegium, it is nowhere mentioned, right? It is something which is born out of the judicial pronouncements. It was born by the through the second judge's case, and then developed completely in the third judge's case. It refers to a body or a group of senior judges. They are meant to recommend the names of those who are to be appointed as judges of the Supreme Court and the High Court. Right? Then there was an episode relating to NJAC. The Parliament brought 99th Amendment. Through it, the collegium system was sought to be replaced by NJAC. We all know that. We are all familiar with that. But the Supreme Court struck it down by declaring that it was unconstitutional because it was going against the doctrine of this the principle that came in Keshan Bharti, doctrine of basic structure, right? Particularly, it was held that it was against, or in a way threatening, the independence of the judiciary, which forms the bedrock of the democracy, right? Now let's understand the step-by-step procedure. So far we have seen the constitutional provisions, We have seen the judges case, how this entire collegian system came into being, and the NJAC controversy, the 99th constitutional amendment. Now let's understand the step-by-step procedure. I believe that after this session, many myths will be addressed. So for the high courts, let's start with the high courts. So for the high courts, for appointment of the judges to the high court, the process begin at the high court itself. The collegium at the high court level prepares a list of prospective candidates, and in doing so, names are considered from the amongst the advocates practicing law, also the judicial officers working in the state. What factors are considered in preparing this list? For advocates, factors like age, generally anybody who is from 40, who is between 45 and 55 years, they are preferred. Then the kind of work they have done, and if there are any pro bono cases that they have dealt with, all these factors are considered among other things, among the eligibility criteria. And for judges already working in the state, their seniority, their service record, their general reputation, all these factors are weighed, and then a list of candidates, it is prepared by the collegium at the high court level. Then this list is forwarded to the chief minister, the governor, and a copy is also sent to the Union Ministry of Law and Justice, and even to the collegium at the Supreme Court level. Then after this, the governments, the state and the union, they seek help of Intelligence Bureau. IB is pressed into action to find out whether there are any issues relating to the integrity and the background of any candidate. And after that, the Supreme Court Collegium, it comes into action. Then it carries its own review. The judgments are reviewed in cases of judges. Then some personal interactions are also carried out. The candidates are called for one-on-one interactions, and then a list is finalized, and that list is then forwarded to the Ministry of Law and Justice. Then through Ministry of Law and Justice, it reaches to the Prime Minister. But Ministry can send back the names recommended by the collegium, but this can be done only once if the collegium reiterates the same names, the recommendations are repeated, then the government has to accept. Then when it reaches to the Prime Minister, then Prime Minister advises the President to make the formal appointment. This happens in the case of appointment of High Court judges. Now, what about the Chief Justice of India and other judges of the Supreme Court? With respect to Chief Justice, the Ministry of Law and Justice, it seeks recommendation from the outgoing Chief Justice of India, and normally the senior most judge of the Supreme Court, his or her name is recommended, and the appointment is carried out. It is very crystallized in a way, right? It is followed as a matter of convention now. With respect to other judges, similar exercise is carried out. Collegium at the Supreme Court level, it considers candidature of the people, eminent lawyers who are working at the bar, and already judges who are appointed, who are working as judges of the Supreme Court or chief justices of the different high courts. Their names are considered. Then some jurists can also be considered for this position. for this constitutional position, and then a list is finalized and the same process is carried out. It will be sent to the Ministry of Law and Justice, and the same things will follow as we have discussed in case of appointment of High Court judges. Right now, with this these documents that are published by the Supreme Court, it is a very good step. Earlier, doubts were raised regarding the transparency of this entire process, and it was believed by many that it has become a more organ centric exercise. Only a particular organ has a say. Judiciary only decides. One person only decides. That is Chief Justice. So various kinds of myth they go around, right now. But with this published documents, we have clarity that it is not the case. The system is built with checks and balances, enough checks and balances at each step of the procedure, which ensures that only the qualified candidates they are appointed, right? Only the dignified people they take these positions. What are these different checks and balances that I'm talking about? First, there is a check at the collegium level, the collegium consultations. They work as a check. Second check is in the form of the quality of work that you have done so far. Then third check comes in the form of intelligence bureau. They will carry out an exercise. They will see whether something objectionable is there, right? Then fourth check is the government oversight over the entire process. And there is one additional check that we have not discussed so far. It is the push for the equal representation from different sections of the society, be it gender based or on the basis of caste or religion. Right, this push also in a way helps in maintaining the integrity of the system, and this also makes the judiciary more inclusive institution, right? So all these checks and balances, they ensure what? They ensure that the judiciary remains independent. They ensure that judiciary remains in a position to protect the constitution, to uphold the dignity of the individual, because it is the judiciary that will be always our last line of defense against any sort of threat to the democratic setup that we have envisaged under the constitution, right? So it is to ensure that people can trust this institution, and that trust is maintained throughout, because it is only because of this trust in the judiciary that democracy can survive. It is the bedrock of the very democratic setup that we have, right? Whether this system is foolproof or not, that is a different issue. And in that context, we must realize that there is no such system. There is nothing on this earth which is foolproof, right? The system works only according to the qualities of people that are actually working day and night to make the system work. It is their dignity, it is their personality that will shape the entire functioning of the system. So we should ask whether it is the system that we need to blame or it is the people, right? But having said so, this step taken by the Supreme Court to make things public, the assets of the judges are also disclosed now, they are on the website. Then these two documents laying down the step-by-step procedure to clear many doubts regarding the appointment procedure. It's a good step. It will address the issue of transparency within the system. And we hope that uh, system continues to improve over the time, right? I can say that I have the trust in the judiciary, and all of us, we should have. And on that note, I would like to thank all of you to join me today in this very, very important session and for learning with me. Thank you so much. And let's meet in another session. Have a good day. Now, only a small part of the day is remaining. So have a good rest of the day. Thank you.